We think, as Americans, that we have the right to do most of what we can do in our own home, in our own yard, in our own farm, without the interference of the government. Unless you are incompetent, we don't allow the government to make those decisions.
These next several presentations are going to focus more and more on the ethical considerations, both medical and legal ethics of what you've already heard in terms of the Mary Northern case. And to present representing clients with diminished capacity is retired District Attorney General for Davidson County, Tennessee, Tori Johnson.
All right. So attorneys are accustomed to providing their client with legal advice and the possible options that there are under the circumstances. Once the attorney has provided the advice and explained the options, it's then up to the client to decide the course of action that the client deems to be in his or her best interest. That is a uniquely personal decision that can take into account a myriad of considerations, many of which may be known or unknown or unknowable to the attorney. In the end, the client makes the decision and lives with the consequences. But what about the situation where the lawyer suspects that the client may be suffering from some type of diminished capacity that could compromise their ability to make an informed decision? Now the attorney must not only provide the advice sought by the client, but also must consider whether the client can or should make the decision, and what the alternatives are if the client's decision-making is seriously impaired. In other words, the attorney not only must provide the advice, but also must be mindful of the decision-making capacity to ensure that the client's interests are protected, a concern that does not arise when the client is competent to make his or her own decisions. Tennessee Rule of Professional Conduct 1.14a states, when a client's capacity to make adequately considered decisions in connection with the representation is diminished, whether because of minority, mental impairment, or some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. While the rule addresses how an attorney should represent a client with diminished capacity, it provides little practical guidance for navigating this type of attorney-client relationship. However, the comments do make several helpful observations. First, the comments note that diminished capacity can cover a broad spectrum of disability. While some clients may be severely incapacitated and unable to make legally binding decisions, many others will be able to make their own decisions about their financial or physical well-being. Second, in the taking of any protective action, the lawyer should be guided by such factors as the wishes and values of the client to the extent known, the client's best interest, and the goals of intruding into the client's decision-making autonomy to the least extent feasible, maximizing client capacities and respecting the client's family and social connections. Third, the comments advise the attorney should consider and balance the reasoning and decision-making process with the consistency of the decision with known long-term commitments and values of the client. The rule with its comments seeks to preserve client autonomy to the greatest extent possible so that the attorney avoids substituting his or her values or interests for those of the client. This would seem to be consistent with the rule's admonition that the lawyer should maintain the normal attorney-client relationship. If a client is competent, the attorney is expected to follow the client's decision regardless of whether it appears to be irrational or ill-advised. The rule makes it clear that when the client has diminished capacity, the attorney should strive to do the same. For an attorney to navigate the numerous issues involving a possibly incompetent client, it is important to consider how the Tennessee courts have ruled in cases where an individual is alleged to be incapable of managing their affairs or make decisions regarding their physical well-being. The Tennessee Court of Appeals discussed the civil competency standard in considerable detail in re Conservatorship of Groves, a 2003 case authored by then Court of Appeals Judge William Koch. The court in Groves emphasized that personal autonomy was the bedrock principle that the civil competency standard was designed to protect to the degree possible. Our state's public policy favors allowing incapacitated persons to retain as much autonomy as possible and selecting alternatives that restrict incapacitated persons' autonomy as little as possible. The court defined personal autonomy as the right of adults to live their lives consistent with their own personal values. A person lacks autonomy when he or she lacks the ability to absorb information, to understand its implications, to correctly perceive the environment, or to understand the relationship between his or her desires and actions. A person is likewise incapacitated when he or she cannot control his or her actions or behavior. But the decision to intervene and to assume control over someone's life is not an easy one to make in view of the public policy that favors autonomy. Consequently, the law presumes a person to be sane and capable, and incompetency must be proven by clear and convincing evidence. The Groves Court went on to discuss the idea of capacity, explaining that it is not an abstract, all-or-nothing proposition. The concept of capacity is task-specific. A person may be incapacitated with regard to one task or activity while retaining capacity in other areas because the skills necessary in one situation may differ from those required in another. As a result, a person's capacity may fluctuate or vary from time to time depending on a variety of factors. According to Groves, a person's capacity consists of two related concepts: functional capacity and decision-making capacity. Functional capacity involves a person's ability to take care of themselves and their property. The more difficult concept is decision-making capacity, that relates to one's ability to make and communicate decisions with regard to caring for oneself or one's property. The decision-making capacity involves the ability, 1, to take in and understand information, 2, to process the information in accordance with his or her own personal values and goals, 3, to make a decision based on the information, and 4, to communicate the decision. Perhaps the most significant point in Groves was that the courts and attorneys should focus primarily on the process that the person employed to arrive at a decision rather than the decision itself. The salient point is that focusing on a decision that seems to be foolish, unwise, unconventional, or eccentric to third persons will lead courts and attorneys to seek to intervene and thereby undermine the public policy of personal autonomy. Just because a court or a person or the person's attorney would not make such a decision does not mean that the person is incompetent and in need of some kind of protection. Instead, by examining the process by which the person made the decision, it can be determined if it was rationally made, at least as far as the person in question is concerned. As Groves noted, the term rational in this context means a decision based on a process of reasoning, not necessarily a decision that the prevailing majority would view as acceptable, sensible, or reasonable. An instructive case applying the principles of the Groves decision comes from the criminal arena. In Reed ex rel Martiano versus the state, a sister of convicted murderer Paul Dennis Reed sought to have him declared incompetent and have herself appointed as his next friend. In 1997, Reed committed 3 robberies of fast food establishments, 2 in Davidson County and 1 in Montgomery County. During all 3 robberies, he attempted to kill all the witnesses and succeeded, except that in one case, a witness was seriously wounded but survived. After an extensive investigation, Reed was arrested and charged with 7 homicides between the 2 counties. Eventually, he faced 3 separate trials and received a total of 7 death sentences. Thereafter, he and his attorneys began a long and complicated appellate odyssey in state and federal court. Approximately 10 years into the process, Reed decided he no longer wished to pursue the post-conviction relief petitions that were pending in all 3 cases. The effect was to stop the appellate process that had stayed his execution for nearly a decade. It was at this point that the sister tried to intervene. If the court granted her request, she would be able to continue to litigate on her brother's behalf and prevent his execution. Reed, on the other hand, insisted he be allowed to withdraw his petitions and be executed. The trial court had to determine if he was competent to make such a decision. Now, there was no question that Reed had mental issues that could bear on his competency to make such a momentous decision. He had been diagnosed with an organic brain abnormality. In addition, he had been evaluated numerous times by psychiatrists and psychologists from his defense team, from the prosecution, and from the court itself. The expert opinions were in marked conflict. Depending on the expert, Reed was either delusional and severely psychotic, or he was a malingerer who had fabricated a delusionary reality to help him avoid legal consequences. Reed claimed he was the victim of government thought control. However, at other times, he said his delusions were an elaborate hoax to fool the mental health professionals. After extensive hearings, the judge in the Davidson County cases acknowledged that the experts were split and that there was evidence in the record that could support either conclusion. She noted that Reed had been able to manage his affairs, both when he was in the outside world and when he was in prison. She also observed that Reed had a surprisingly good grasp of his complex legal issues. At times, Reed would explain that he wanted to end the appeals process because he did not want a new trial where witnesses would say terrible things about him. He also thought new trials would be futile because he had been convicted in all 3 cases previously. At other times, he said that if the death sentence were carried out, it would free him once and for all from the government's mind control. At one point during the process, he told the court's mental health expert that he didn't appreciate all the people that were, quote, badgering him to change his mind. He strongly believed he was entitled to his opinion, regardless of what others thought. He said he had had a trial. Quote, "I don't appreciate the outcome of the trial, but I live with it." The trial court evaluated the evidence using the guidance found in the Groves decision. She admitted that it was a close call and one where the evidence was split, but in the end concluded that Reed's sister had not carried her burden to establish by clear and convincing evidence that her brother lacked the ability to make a rational decision regarding his appeals. As a result, Reed was able to make his own decision about whether to withdraw his post-conviction relief petitions and cease his appeals. A similar decision was made in the Circuit Court of Montgomery County. On appeal, the Tennessee Supreme Court stated that it would not disturb the trial court's findings as to the credibility of the witnesses and the weight to be given their testimony, and that the court had correctly used the principles set forth in Groves. And in the Reed case, much like in the Northern case, he died before any of this really became significant. The Groves and Reed decisions give context to the difficult ethical position an attorney may be in when with a client with a possible impairment. On the one hand, the Rule of Professional Conduct 1.14 advises the attorney shall maintain a normal client-lawyer relationship, which implies the attorney is the client's advocate to whom he or she owes the duties of competence, communication, confidence, and loyalty. In such a situation, the lawyer is expected to provide the client with advice, allow the client to make an informed decision, and then take whatever steps are necessary to see the client's decision is implemented. Clearly, the courts in Tennessee prefer this approach because it seeks to preserve the client's personal autonomy. Yet at the same time, the ethical rule cautions the lawyer to be ready to act if he or she believes the client has diminished capacity and is at risk of substantial physical, financial, or other harm. This provision can set up a conflict between the client's decision as to his best interest and what others believe is in the client's best interest. This is a precarious position for the attorney, who then may be advocating against his or her client's express wish. As Tennessee courts have pointed out, it is not enough that the decision of the client is peculiar or unwise or not what the attorney would do under the circumstances. Rather, the process must be irrational when considering the process by which the client arrived at the decision. More importantly, if the attorney seeks court action to protect the client, he or she will have the burden of proof on the issue. The other looming issue is the time and expense that litigation necessary to protect the property or physical well-being of the client. Either could require expert witnesses and multiple attorneys at considerable costs. For many clients, this is not a viable alternative. An attorney who has an impaired client should proceed with caution and seek to protect the client's autonomy. If some degree of protection is warranted, the lawyer should look for the least restrictive alternatives necessary to accomplish the goal. This may include working with family members, community organizations, or licensed professionals. Regardless of the course of action the attorney takes, the lawyer should thoroughly document the steps in the process and the efforts he or she made to preserve client autonomy. Thank you.
All right, now we get into ethics, both medical and legal. And to do that, we have three presenters, and I'm just going to mention their names, and then when Frank comes up, Frank, if you can just introduce each of them as they come up, and then you won't have to see me again. And I know you're all happy about that. Frank Grace, retired from the Water Law Firm, will begin, and then he'll be followed by Carl Warden, who's in private practice here in Nashville. And then we're pleased to have as a guest presenter today for this program, Kate Payne, who is a professor of nursing and also at the Vanderbilt Medical Center and involved in the Center for Biomedical Ethics and Society. So Frank, come on.
In the materials that are online, I titled this little presentation, the Mary Northern Case 40 Years Later, What is a Good Result? And I posed that question of a good result based upon the comments and some subjective judgments made by Dr. Benton Atkins, one of Mary Northern's treating surgeons, in a 1980 medical journal. Dr. Atkins was of the view that, quote, we could have achieved a good result and saved Mrs. Northern's life if we'd been left to our own devices. He went on to say that although the court system had been fair in all respects, and that the surgeons had the necessary authority to proceed, they never made the required certification of imminent death because of the public furor that would have been raised by the guardian ad litem. Unstated was the fact that the guardian ad litem was a lawyer. As you heard earlier in the hospitalization, that Dr. Tackett had mentioned to Carol McCoy that her legal shenanigans was going to result in the death of Ms. Northern. In his concluding remarks in his article, Dr. Atkins complained that the medical profession had to concern itself with a number of outside influences, including the media, the legal profession, the consumer, perhaps that's the patient, public opinion, and pressures from the federal government. These comments and formulations reflect an adversarial, almost zero-sum assessment of the issues involved in Ms. Northern's case or similar cases. Specifically, if the medical judgments prevail, the physicians and patient win, while the lawyer loses. If the lawyer wins, the patient and medical profession lose. Sadly, this seemingly unbridgeable gap was the result of well-intentioned adherence by practitioners to the ethics of their respective professions. On one side, the physicians were focused on saving the life of the patient and obtaining the best possible outcome for continued life. While on the other hand, the lawyer, as a zealous advocate, sought to assert her client's individual autonomy to make her own health care decisions. Fortunately, if a case such as Mary Northern's was presented today, the healing hands of time have created a statutory and regulatory context and a much more collaborative process that is focused on the patient's rights and desires and not winners or losers, or at least dissatisfied antagonists. I had to get my Willie site up there on healing hands of time. The recognition and empowerment of the patient's rights and desires can lead to a good result, although good may not be the right word in the context of some of these cases. Once a patient such as Mary Northern is hospitalized, today in virtually every instance, the hospital would be the initiating party to any litigation and not a state agency. State and federal regulations plus accreditation standards designate the hospital as the responsible entity for the overall care of patients and the quality of that care. An essential component of quality care is the hospital's duty to protect enumerated patients' rights, which specifically include the right to give or withhold informed consent to treatment. In the 1970s in Nashville and nationally, hospitals began to look to lawyers in new ways to protect them from liability claims, as well as compliance with the growing statutory and regulatory standards pertaining to the documentation of quality care. Specifically, because of skyrocketing rates for medical malpractice coverage, hospitals began to self-insure their liability risk. Humana and HCA, for example, formed their own insurance companies. Baptist, St. Thomas, and National Memorial had their own self-insurance plans. In practice, what this meant is that the hospitals now had first dollar exposure to losses as well as the responsibility for defense costs. In response, the hospitals hired risk managers or expanded their roles, and the risk manager in turn began to work closely, if not daily, with hospital lawyers to minimize potential losses. Among other things, these collaborations involved reviewing policies and procedures that address patient care to ensure that they met the regulatory and accreditation norms and that they in turn were properly implemented and enforced. The protection and honoring of patient rights are essential components of this process. Quickly, particular rules of professional conduct came to bear, specifically 1.1, dealing with the competence to properly deal with particular client needs, and 2.1, that pertains to a lawyer's role as an advisor. In this latter role, lawyers began to see that quality concerns and the protection of patient rights called for the involvement of other professionals, such as, and not limited to, ethicists, psychologists, counselors, and social workers. Today, almost 90% of hospitals have some form of interdisciplinary ethics committee, and many employ professional medical legal ethicists. While lawyers are not involved in any clinical decisions, they are resourced to these committees and often sit in their deliberations. From a legal ethics standpoint, perhaps the overarching lesson to be taken from Carol McCoy's representation of Mary Northern was her zealous advocacy of what she viewed as Ms. Northern's rights. Carol did not have a lot of law on her side compared to today. The autonomy of competent patients to refuse medical treatment was not uniform across the country until 1990, when the U.S. Supreme Court in the Cruzon case held that competent patients had a constitutional right to refuse medical care. That hold is now codified across the country by statute and regulation. The Cruzon court also held that patients lacking decisional capacity possessed the same rights, but it left it to the states to implement their own standards with respect to these patients. This is not just an incidental holding. The issue of patients' lack of capacity is a significant and ongoing concern. And for our purposes, capacity and competence in the Groves case are used interchangeably in Tennessee. In a 2017 article in the New England Journal of Medicine, they cited studies that estimated the decisional incapacity approaches 40% among patients in hospitals and residential hospice, and 90% among adults in ICUs. One approach devised to lessen the impact of patients losing their decisional capacity was the use of written advance directive advanced prior to disabling events. Tennessee enacted a living will statute in 1985 and followed with a durable power of attorney legislation in 1990. Unfortunately, probably only a third of patients with capacity issues execute any advance directive. Clearly, there's a critical need for a mechanism to identify, designate, and empower surrogates to act on behalf of incapacitated patients. The Tennessee legislature responded in 2004 with the Healthcare Decisions Act. The HCDA directed the Board for Licensing Healthcare Facilities to develop model advance directive forms for general use in hospitals and nursing homes. For those still without an advance directive, the HCDA provides a detailed process for evaluating, appointing, and enabling surrogates. Surrogates are to be drawn from a delineated list of family members or other concerned individuals possessing particular characteristics to make them appropriate patient representative. This is a process designed to take place within the institution and is to be carefully documented in the patient's records. Properly followed, the selection process does not require court approval, possesses the presumption of being correct, and places the burden of proof upon any challenging party. I will leave the definitional and operative details of the day-to-day implementation of the surrogate process to others actually involved, Kate and Carl. And similarly, I'll defer to Carl, a specialized practitioner in the representation of the unfortunate segment of the population that lacks decisional capacity, any advance directive, and is without an appropriate individual to act as their surrogate.
My presentation is called Being an ELHF, pronounced ELF, Expedited Limited Healthcare Fiduciary. And yes, I did once threaten to wear ELF ears in court. You do not get to be appointed as a fiduciary by a court as a third party when the patient is on a winning streak. There's already been a determination by the hospital personnel, that there are no other people who will take on the task or who ought to be taking on the task. And that includes family. So you get appointed because somebody has to step up to the plate, also because the Healthcare Decision Act does not provide for making financial decisions to get the person out of the hospital. Once you become a fiduciary, you have the task of providing health care for that person. You have the task of providing a place for that person to live and to make sure that there is a source of funding for that person to live in a safe and productive manner. You are to get the ward in a safe place, one that takes care of the medical and personal needs. You have to make sure there's a way for placement to be paid for. You have to make sure that they have clothing and furniture when necessary. And you have to do this while giving the ward the most personal freedom consistent with their health and safety. Placement in a safe place where the ward can be adequately cared for is a little more difficult task than you might think. Many wards are in the position they are in because they've worn out their welcome with family and with group homes. Paying for care is both important and difficult. There are public assistance programs like SSI and TennCare. Those programs require proof of financial need. Both SSI and TennCare require that the person have $2,000 or less in available funds. TennCare wants the last 3 months of bank statements. Getting that information can be a problem, especially when the ward cannot or will not provide any cooperation with obtaining that information. You also need to know what they've done with their money and possessions over the last 5 years, assuming they can remember. Most of the time, the hospital will have a staff or service that helps obtain benefits. This is a real boon because they can access information about health coverage that you cannot easily, as a layperson, find. That assistance comes at a cost, though. The hospital made the TennCare application. TennCare will not talk with you. Frustratingly, TennCare has no mechanism for sending in a court order appointing you as a fiduciary, so you end up having to do a separate TennCare application and hope that you don't mess up their benefits while you're at it. You should be prepared to work hand in glove with the hospital that made the referral, as well as with other qualified medical providers. No matter how much you think your common sense is going to be enough, it will not be adequate to the task. People with mental disorders significant enough to merit the appointment of a fiduciary are not going to act in ways that can be positively affected by common sense most of the time. Ask, don't assume should be your motto. You should also always approach your task with the firm knowledge that the people with whom you are dealing are as worthy of compassion as you are. Yes, they may be quite off-putting or even scary at times. That is part of the reason why they need help. Treating your wards with dignity and allowing them the most freedom compatible with their own health and safety is your most important task. One of the first people for whom I was a fiduciary was a little old lady in an assisted living center who was thoroughly demented. I would take her to doctor's appointments, and on the way back, she'd tell me all about how it was that she needed to get back to the office, and her father would be waiting to pay for me. She had language that would make a sailor blush. And I tended to see her just as a little old lady, but what was actually going on was this is a full human being with a full human life. Only later at her funeral, I saw a picture of her standing in stylish hair for Nashville, yes, a beehive, with white-rimmed Ray-Ban sunglasses in front of the plane where she had just soloed. And I realized that there was a whole lot more to her than I had seen. In a coincidence that I think is a little bit interesting, a few weeks ago, I got called by Vanderbilt Hospital that one of my wards needed one of his feet amputated, and he didn't want the foot amputated. I immediately emailed Carol and said, hey, guess what? So what did I do? I went and I talked to the medical staff. I talked to them about what was going on, why they thought this was needed, what they thought the consequences would be. I discussed it with his family. I got the family's input and their support for their family member, and then I discussed it with him. We talked about his fears, we talked about the consequences, we talked about the fact that there's new prosthetics that make this better. We talked about the fact that my great uncle accidentally shot off both legs below the knee in a hunting accident years ago and had a great life. And we talked about his responsibility to his children. And then I let him decide what he wanted to do. And ultimately, he decided that having a foot removed and living was better than not having a foot removed and dying. Your wards may not always get better. In fact, they stand a good chance of getting worse. Some die. Your task is not to get them better. Remember, whole teams of medical personnel were working on that before you got there, and they were not succeeding when you got appointed. Your task is to seek guidance from professionals, treat your ward with dignity, and do the best you can. Speaking of the professionals, here's Kate Payne.
I keep thinking I'm in the wrong room. But you will see from what I'm going to say that the law and ethics is closely related when it comes to my job as a medical ethicist. You should know that no one ever calls us up to say, things are great, all the patients have capacity, thank you. or they have great medical directives, come up for pizza at noon. No. So my role today is to tell you a little something about the development of medical ethics and how it interfaces with decisions related to incompetent patients. I kind of feel like I should make a small disclaimer that how we do it at Vanderbilt is very much affected by the fact that we have a whole department for ethics, in addition to some of the other resources, and so how we do it may not be how it works at a smaller hospital. Bioethics, also known as medical ethics, clinical ethics, and healthcare ethics, are all terms for the same thing. They all speak to the ethical issues that arise in the care of patients. Healthcare ethics is a more modern and expansive term meant to take in the whole continuum of healthcare, all the people that care for the patient, from birth to death, research to treatment, etc. It has its origins and evolution in the old and ongoing debates over human experimentation, the new ones about the human genome, technology, and high-dollar drugs, as well as ongoing questions about organ transplantation, terminating life support, and defining death, as well as reproductive technology and defining when life begins. You may have seen the reports where someone has taken the brains of deceased pigs and made them come alive again, questioning, is there really brain death? Many of the early ethics cases were yet to be answered questions for both health and legal providers, and Mary Northern is a case like that because, as was pointed out, there wasn't a lot of legal support for what she was doing. Ethics committees are somewhere just over 50 years old. I've been doing ethics for about 25. They are the most common mechanism for dealing with ethical issues in American hospitals. About 95% or better have one. The traditional roles are three. 1, education of the committee itself and the institution it serves. 2, policy review, implementation, and development. The policies in the ethics basket are the fun ones, like withdrawing life-sustaining treatment and do not resuscitate issues and brain death and organ donation and all that kind of fun stuff. The third role is case consultation and review. This can be done by a committee or part of a committee. Individual consultants are less common, but not uncommon in large teaching hospitals and some faith-based systems. Ethics consultation is found in about 80% of all general hospitals in the US and about 100% of hospitals with 400 beds. A recent study reported last week at the large bioethics meeting in, I think it was Pittsburgh, about 29,000 people lay claim to doing this. So if you figure there's 6,000 plus hospitals and everybody's got an ethics committee, that gives you about 3 or 4 people that are doing this in every American healthcare facility, something like that. The beginning and the sustaining ethics, to begin and to sustain ethics mechanisms, it tracks with technology. I have a job because we have all this interesting technology. In the US, the modern committee can kind of be tracked back to Seattle in the 60s, where Belding Scribner, a nephrologist, made dialysis possible the way we know it today. Before that, you could only have it so many times because it would ruin all your vasculature. Scribner had developed a good kidney replacement machine, but he only had 17 available. So once he developed this better process, it raised the question of who would get it and who would not. Scribner's answer was to form a committee. This is always what we do at the medical center when we have a problem, we form a committee. You may do that too. His was interesting in that it was made up of laypersons from the committee where the hospital sat. His thinking was that they would be better able to come up with a fair response because they were part of the community. So they made criteria for who would get dialysis and how they would implement it, and then Scribner went public with it in an attempt to raise awareness and advocate for these patients. It was front page news in the New York Times and several other publications, but it came to be viewed negatively as the Seattle God Committee or the God Squad. This idea of criteria and the process they went through remains somewhat in how we think about organ donation criteria today. And the deliberations they made on what to do when new technology happens and there's new options are common in today's ethics committees. Decisions are value-laden, but the hope was that that committee would best be able to do it. The modern ethics committee is probably made up of disciplines from throughout the hospital with a few lay members or none at all. Through the 60s and the 70s, there were many cases and controversies, both in human subjects research. Henry Beecher, an anesthesiologist, put a big paper out documenting all this research misconduct by lions in the field. But there were also 2 cases, one of which has been mentioned already, that really inform ethics practice today. One was the Quinlan case, a New Jersey Supreme Court case in 1975. It was really the first major public idea that there would be decisions to stop life support. Quinlan had overdosed, become comatose, and was on mechanical ventilation. Her parents asked to have it removed, saying she would not have wanted it. The New Jersey court agreed and also noted that an ethics committee might play an advisory role as an alternative to the court fearing, because there were so many of these cases, that they would be overrun. The second big case was Cruzan, as you've heard, and the Cruzan family actually did win that case, asking to have Nancy taken off of a feeding tube. They won that, but the state actually won the evidentiary question. But the important part was what Frank talked about, was the idea that a competent patient retains those rights, and if they can't execute them, then someone else can, which brings in the whole range of who is that someone and how do we determine that. The Cruzan case eventually led to the passage of the Patient Self-Determination Act in 1991, which underscored the patient's rights to direct their care by mandating, among other things, that patients be informed of such rights and offered information about an advance directive. You know this if you've been hospitalized lately, because we are mandated to ask everybody, even women laboring. Never goes over well. Another major push in the development of ethics committees came in 1992 when the Joint Commission on the Accreditation of Healthcare Organizations made a mandatory recommendation that if you were accredited, you had to have an ethics mechanism. It's job security. So running on parallel tracks at the same time was the developing role of the individual ethics consultant. The earliest consultants came from outside the clinical team. Most were humanities professors, philosophy, religion, sociology, anthropology, law, and like myself, clinicians with additional training in ethics. They came into the medical school and the clinical environments to help respond to the rapid change in technology and to really instill or reinstill a more humanistic orientation to medicine and its varied practitioners. The concern was that the patient was being lost in all that medicine was too task-oriented. Mostly the concern was that we were beating the humanity out of the students and trainees. In patients that lack capacity, healthcare providers are very uncomfortable about taking decision-making away from people when they don't have it, even when they don't have it. Ethics consultants help with support, but also as a check and balance to make sure there's been due diligence related to a reliable capacity assessment, finding family or friends that might help in assessing their appropriateness and their own ability to make decisions. You will not be surprised that family dysfunction, money, and power is often at stake in these cases. Ethics consultants also help determine a plan for people that have no people and can't make decisions. As Frank pointed out, the Healthcare Decisions Act has a pathway for the treating physician to actually take over the role of decision-making, which sounds like a conflict of interest on steroids, and probably it is, but it works. Consultants then work closely with the social worker and the providers, as well as the legal department for those patients that will be incapacitated for a long time, often making the recommendation, this is me almost every week, I think you guys need an ELF, at least as a starter. Providers actually really like ELF appointments because of the temporary nature of it, hoping that the patient will regain their ability to make decisions. I actually think ethics consultation by individuals or committees is about creating space. It creates a moral space that allows for a safe conversation, as the questions are really difficult and the work is hard. It is really hard to admit as a physician that you can't heal the patient or the patient can no longer guide their own destiny. The consultant is not, however, the person that rides in on our ethics steed of virtue to fix things, but we are there to stand with the physician members of the team, the patient, and the family to provide support and aid in problem solving.
All right, that is great. I'll invite Mr. Hubbard and Ms. McCoy to come to the stage, and I've been told that this microphone is mobile. It appears to be. So I'm going to go over there and be a little closer to my panelists. You already know who all these people are, but you've really only seen Carol by video. This is the real Carol McCoy. And I don't know where they want me to stand. I haven't done this before. But actually, we did this in Baker versus Carr, but it was 7 years ago. I forgot how to do it. So you know who all these folks are, and the purpose of the panel is to try to, fill in the blanks and answer questions. And I don't know if we'll have time to do questions from the audience, but if you have one that you just can't resist, in the last 5 minutes, we'll see what we can do about that. But have you noticed that there's a fact that we have left out? No? Maybe we didn't leave it out very well. Carol, when did she die and of what cause?
She died the 1st of May in 1978 of an embolism. The doctors, I think it was April 15th, had made their press announcement that they weren't going to have to do surgery, that she had sustained the gangrene, and she was recuperating. It was put in the press that the reason she had this blood clot was because of the antibiotics that they had given her to help overcome the gangrene.
Okay. So to me, that generates a follow-up question as to whether Mary Northern was right after all. She obviously survived the condition that she had when she first entered the hospital, and it made me want to ask Bill Hubbard, my good friend from Southwestern, a fellow Lynx cat, more than 50 years ago. Do you have any second thoughts about the case?
You mean as far as my role?
Well, just, you know, if you knew then what you know now. Next year is 2020. Everybody knows that, right? And hindsight is 2020. So this is the year of hindsight. Like that? I'm giving him time to think.
Yes, well, I mean, my involvement was at the Court of Appeals. I was not involved in the trial court. And I think my role at the Court of Appeals was pretty well defined. And no, I don't know of anything that I would have changed.
Okay. I wanted to ask Kate about this. This is something that just kind of occurred to me, and I'm probably off base. I frequently am. But it occurred to me that this was 1978, and I think less than 5 years earlier, the decision of Roe v. Wade was made in the U.S. Supreme Court, and we all know what that's about. And Roe v. Wade obviously had a lot of language about the right to privacy and the right of a woman to make determinations with respect to her own body. Is there anything about that decision that you think might have been brought to bear in the Northern case?
So, you know, ever since I got involved in this, I've been trying to think how it would happen now. But back then, I think that was a piece of the picture, but not for the doctors. So you can tell from the story that you've heard that the doctors never really thought about her rights or her. They just had this idea that we have to cut these legs off or she's going to die. It was this very sort of direct response. So I don't think that factored in how they thought about it, but it certainly factored into how one advocates for a person, that each person has the right to make their own decisions. But no one ever talked about it that way that I'm aware of. But that would have been a fascinating way to think about it.
Yep. We've heard the names of several local attorneys that some of you may know, if you're old enough. Jay Slobey, who was at the legal department. Greg Galloway, I believe, was a staff attorney for Department of Human Services. Bill, did you interact at all with them?
Well, Greg Galloway is the one who, as I recall, contacted me and got me involved and explained to me what was going on. Beyond that, I really didn't have any contact.
We actually contacted Greg, but he didn't feel that he remembered enough about the circumstances to participate. What about Carol? Did you deal with Jay or Greg at all?
I dealt with Greg the very first time that I went to court because he was presenting the application to Chancery High.
Mm-hmm.
And then there was the day later when I was dealing with Bill and Patsy Cottrell. I didn't really deal with Patsy that much because I think Bill was the one that took the lead on contacting the appellate court when we were going up to the Court of Appeals. And he's the one that told me we were going to the hospital after we had our oral argument.
That brings up another question. Somebody mentioned this at the break. Let's just deal with it right now. This is all happening incredibly fast. I mean, how long was it? 2 weeks total?
I think that we got to the Supreme Court within 1 week, maybe 10 days, and then we got back to the Supreme Court within another 10 days, I think.
Okay. But that first week, very intense, every day, right?
I was there Wednesday, Thursday, Saturday, and the following Friday, I think.
And then when you're not there, meaning in
Tuesday.
court, you're back at the office drawing up briefs and writs of supersedious and all this kind of thing. The idea of not doing what the client wants when you feel the client is competent does bring up substantial moral issues. And you've told us about the doctor who made, I think, the rude comment that it was all your fault. But you sought some advice. Jody, if we could play clip number 1, I want to ask everybody about this.
And I thought, I will call a priest. And I did. I called somebody over on Belmont at Christ the King. I didn't go there, but that was the nearest Catholic church I could find. And I ended up talking to one of the priests, and he said, as long as she is not hurting herself or hurting others, then there is nothing that she's doing wrong, and you have done everything that I've heard in the news. You're doing what she wants, and that's the right thing to do. And after that, I have to say, I felt good with my conscience, and I felt like I was doing the right thing. It wasn't like I had gotten some lawyer to tell me I was doing the right thing. In my heart, I knew I was, but in my soul, I needed some affirmation, and that's what I got. And from that point forward, I had also had a talk with myself, and that was, it was not my job to talk her into having the surgery. I cannot imagine anything more worse than being flat on your back, people coming around saying they're going to take your feet, and having your own lawyer come in and say, don't you think you should have the surgery? At that point, you have no hope. You have nobody to count on. And I was that little thin thread that she had, some hope that they wouldn't operate on her.
All right. Now, Bill's brought up a good point, and that is that everybody in this case and everybody in the court has a role. But what about when your role and your moral convictions may become in conflict? Is it just, you have to do your duty, and what do you do? And Kay, I guess you're in the middle, so I'm going to put you in the squeeze here, because I think we kind of know what these other two folks think about it.
So the technical ethical term for that is moral distress, when you know the right thing to do and some kind of constraint prevents you from doing it. It's usually the impetus for someone calling our office. So I think it depends on what the thing is. So some duties you have to do them or not, other duties you negotiate. So that's kind of the fundamental question here in this case is what's negotiable here actually? And that goes to Frank's statement about, was this a good result? What really was actionable here? Where could there have been a different decision, et cetera? I think if Mary Northern happened today, there would be a deep dive into the question about how she talked about her feet. And this is a way to kind of get at what you're asking me. So if I feel morally conflicted that we might take her to the OR, I need to be damn sure that that's a good idea. I need to be damn sure that she has capacity or not. So there'd be a deep dive into how she would talk about her feet. But I honestly don't think, and they may have found the same thing, that she lacked capacity, but I don't think they would have thought it was a good idea to take her feet off now, given everything else that was going on with her. And then thinking about the house and that she really couldn't go back there. But hard to say. It depends on how she would answer those questions.
I have one other response, and I think if you have very deeply held moral convictions, and you're being asked to do something that you think contravenes those principles, whether you're representing somebody in high office or whether you're representing somebody in a bed, if you cannot go forward in good conscience, then you need to step aside.
Agreed. Yeah, agreed. And we say that all the time in the hospital. If you can't do what the patient's asking, you need to find someone who can. So abortion is a good one to think about that.
Okay, now that's very interesting. If you can't find some, say it again?
If you can't do what's needed by the patient, so your tightly held beliefs prevent you from doing that, and the patient has a medical indication, then we have to find someone who can. So we have rights of conscience, and
Yep.
so if you're going to refuse to do something the patient needs, then we need to find someone who can.
I have a memory, I think it was 1983, I don't know the reason I remember that, every year I was privileged to be president of this bar, and we had the TBA convention out at the Marriott next to the airport. And we had a really dynamic speaker, somebody that had come in from out of town. You know, they always come in on planes with briefcases. And the exercise was for members of the audience, just chosen at random, to get up and argue a particular side of a case. And Justice Fones, who was at that time on the Tennessee Supreme Court, was in the audience. And he was called on to argue a side of a case that he disagreed with. And he refused to do it. Now, you know, that's a long time ago, but is that similar to what you're saying? In other words, you might have a moral conviction that just doesn't allow you to be the lawyer in this particular case.
So you got to step back. And it's probably different in the hospital than it is for lawyers. But
Okay.
could you have stepped away from that case?
I didn't have a problem, so I wouldn't have stepped away. But I have had a problem with a client who lied to me and wanted to go into court and persist in keeping that position. I'd only represented her for 6 months, and I wrote her a 2-page letter that I couldn't condone her testimony if she was going to persist in making these representations to the court, and I was withdrawing. And I think it is easier for a lawyer, because some things are black and white, than it is for a medical professional. I think it's much harder for a physician. 20 years after the Mary Northern case, my very best friend's mother, who had cared for her mother-in-law, a double amputee at the knee, and who for the years of my friend's life had said, I will never have an amputation, was at St. Thomas Hospital in 1998. She'd been air vac from Pulaski. She had lost kidney function. They got her into the hospital. 2 days later, they said that because of the loss of kidney function, they were going to have to amputate her 2 feet. And I was with my friend at the hospital all that time. They had the ethics committee. They had the pastor. They had everybody, and she was alert. And they wanted to do the amputation, and she said, I will never have this amputation. And my friend cried, her brother cried, her husband was very sad. They all knew she had been very consistent. 3 days later, she lapsed into a coma, and do you know what? The ethicist, the doctor, the pastor all came back and asked the family to reconsider. And I have to tell you that I thought that was one of the cruelest things that's ever happened. Mary Northern was a little cruel, but I think putting a family through that twice, knowing the wishes of the person who's involved, and she did die. She died within a few days of lapsing into the coma. But I thought we'd come a lot further.
Yeah.
Now, Kate, one of your slides had brought into the dialogue here the right to die cases, and I know that at different times Carol has said it was not a right to die case, even though I think Bill at one point may have thought that it had some similarities, and I think he's right about that. But Jody, let's play number 3, see what Carol said initially, then I want to ask a question.
The courts have not given the doctors very much guidance on those issues. Life and death issues are very hard for any of us to deal with in our own personal life, and yet we expect the courts to come out with some resolution. And at the same time, the courts are the ones that hold doctors accountable for the decisions that they make. This right to die case in the John J. Hooker situation, I studied that statute, and it says it is against the law to help people commit suicide. Blank. You can't do it. That's paragraph A. Paragraph B says, however, if you are giving an individual medication to ease their pain and suffering, regardless of whether it causes them to die, so long as you do it with the intent to ease their pain, you're not liable.
However, don't you love that word? You know, the judge is about to sentence you to 100 years and said, however. Then you love it. You were presiding over the Hooker case as a chancellor.
I did.
What are the similarities? Or are there any? Hooker and Northern.
Well, I think there are some similarities because John Jay did voice his expressed desire as to how he wanted to end his life. Mary Northern expressed her desire as how she wanted to continue her life. And so you do have those similarities of dealing with what is the patient's directive. John Jay did not have as strong an advocate as I did when I was representing Mary Northern because maybe he did. Neither one of us won.
No comment.
The statute that I just referenced really put the nail in the coffin as to his legal proceedings. The physicians had said they were willing to give him medication to ease his pain and suffering. Their affidavits were very carefully worded and complied with the statute. They didn't say they were going to give him medication with the intent to end his life. I think the fact that we have come further in the legal world about dealing with some of these issues is beneficial, and it does give some guidance to the physicians. I have 2 sons who are going to medical school. And the oldest just finished a week on the palliative care ward, and he talked about how hard that is to deal with patients who only have hours or a day or 2 to live. And I will tell you that I don't think there are very many lawyers right now who have a client that they know they have an hour, 2 hours, 3 hours, or a few days to live. We just don't get involved in those kind of issues on a day-to-day basis like physicians do.
Yeah. Bill, you want to weigh in on that?
Well, I want to weigh in on one statement that Carol made that I disagree with.
Good. We like that. No. Kate, relax for a minute.
Is it bad that I'm sitting between them?
That's right, that's right. No, Carol and I are
Old friends.
old friends, that's right. I would disagree with Carol when she says she did not win the case. I think she did win the case. That at the trial level, it was being treated in sort of a summary fashion. In other words, Ms. Northern was removed from her home. The chancellor authorized the operation. The social worker was, I believe this is correct, provided the testimony on the competency, capacity. And Carol's advocacy turned the case around. And I don't mean that she, that the issue of whether Ms. Northern's amputation was going to take place was finally decided. But the issue was addressed in a totally different fashion. And in fact, as you saw, the Court of Appeals took it over. The two attending physicians and the psychiatrist testified, as well as Ms. Northern herself testifying. So I would actually argue that Carol won the case. She got the issue treated and she got the issue considered in the manner in which it should have been considered from the get-go.
Bill Hubbard is one of the smartest and nicest lawyers I know, and you just saw evidence of that. Kate, right to die. How is it being handled as a practical matter now?
So, as of October 1st, there are 10 places in the U.S. that you can get physician-assisted suicide. So Maine and New Jersey legalized on the 1st, went into play on the 1st. So 9 states plus D.C. So that means like 1 in 20 Americans has access to physician-assisted death if you meet the criteria. So regardless of whether you agree with that or not, the fact that this has been an open debate has caused us in healthcare to be better about end-of-life care in major ways. How we talk to people about it, we train medical students, nursing students, pharmacy students, PTs, OTs, how to have difficult conversations, how to be honest and caring when saying to a patient, I can't fix this, how to talk to a family, how to do advanced care planning, fill out your living will and that sort of stuff. So that's the silver lining. We're much better about managing pain with lots of things besides narcotics. We have palliative care units. Palliative care is total patient care, physical, psychological, social, and spiritual. We have hospice, one kind of care, one kind of palliative care where life expectancy is 6 months or less. These things are so important, and it used to be when I would talk about this around the country, I would say things like, only about 20% of people get a good death. Now I get to say it's actually totally flip-flop, like the vast majority of people now get that access. So this conversation about the right to die or just good end-of-life care, that's been the blessing of the conversation. But it's a compelling question that John Jay asked and that every patient or every person who advocates for assisted death asks. Why should I, as an autonomous person, knowing that I'm going to die and I have this terminal illness and I just don't want to get to that place of terrible pain, why can't I choose now? It's very compelling. And so that's what all the different states that have legalized are looking at. So I think it's on balance, I think it's good, but it's scary still.
Well, that's good. You know, there's some irony here. Good death. Have you heard that one before? That term. There's some real irony here, folks. This may be the last thing I'll be able to get in. 7 years ago, when we started all these things, Jody Bailey, our technical wizard up there, and I went to a studio out on Elm Hill Pike, same place, same room where we did Carol's video just a few weeks ago. And we did a video interview for about 90 minutes with John J. Hooker. And that's what lit the fuse that's still burning, still glowing with these things going on as long as they have. And he had a statement that was very profound. I think we included it, perhaps both in the Baker versus Carr and the Hoffa presentation, but it was this. He said, one man can make a difference, and every man should try. I think we've amended that today. One woman can make a difference, and every woman should try. Carol McCoy won the case, been conceded by the state of Tennessee, acting by and through its former Deputy Attorney General. And the legacy of John J. Hooker, a very interesting and talented man, lives on. Let's give these folks a hand for a really fine presentation. Now, before you leave, be sure you've got your purple form, purple, Jim, is that right?
You know, it was the first
Fill it
case
out
I
and
ever heard
hand it in,
about. Yeah, so when I moved
and
here,
thank you for coming.